Hello, YouTube. I'm Vince White. I'm an employment attorney, and at the moment you're seeing this, if you're seeing it shortly after it's posted, I'm in Utah. I'm not in Utah now, but I will be. So I'm trying to film a couple videos ahead of time here and make sure that I don't fail you. People tell me they like their daily video. I've heard it from a couple different people, which bowls me over. I would not think anyone cares about these videos except the specific people getting the answers. But I'm thrilled to hear that there are people who like to watch the videos every day and who value the videos. That makes me feel useful. Makes me feel like I'm helping people. So thank you. We had a question on the channel a while back that I'm just getting to answering now. I thought it was a really clever question. It was I think it was a question posed by Pamaroon. Username Pamaroon, which is a very cool name. What are the best and worst tactics to employ as a applicant in an unemployment benefits hearing? Okay, so let me first say unemployment, the laws that govern unemployment, the unemployment agency is different in every state. All 50 states have slight differences, have slight distinctions, and so you need to be aware of that. Whatever is the law of the land where you are, or best practice where you are, you should look into that. You should follow that. That is going to be very important. I am purely giving the most general of advice here, like the basic. Second disclaimer: administrative law judges. Those are the people who decide cases in New York State and in many other unemployment benefits agencies. They're human beings. They're all different. So different. Like incredibly different. I have seen ALJs find and utilize the skills of Plato and Socrates and the great jurists of history to get at what I think is a close approximation to the best decision in a case. And I've seen an ALJ just swear up and down that human beings can't bend at the waist. I assume we're all on the same page that human beings can bend at the waist, right? That we all agree on that. That is something that I saw written by an ALJ in a decision. No, this couldn't happen. Humans don't bend that way. They can't just bend at the waist. Part of our evidence in the case was a video of a human being bending at the waist. Right? So, ALJs, human beings, not all the same, unpredictable. Be aware of that. This is, again, general advice. You're going to have to do your best to read and get a feel for the specific ALJ that you're dealing with. Okay? Now, let's get to it. What is the absolute worst thing to do in an unemployment hearing? So you need to find out what they're saying is the reason you should not receive benefits, right? That's where you start. If you're not starting with that, you're wasting your time. Like people come in, they're like, I have 30 character witnesses. I'm swell. No one cares. That's not a thing. That's not a thing at all. The standard in New York is, did you resign? If you resigned, was it so bad? Was it a constructive termination? Things were so bad that you had no choice but to resign, or were you fired for cause? Right? Though that's kind of the question in New York, right? So you're going to receive benefits if you were fired, but it wasn't for cause, or if you had a constructive termination. And constructive termination is a very difficult kind of uphill fight. So we're going to set that one aside. We can talk about it more if you want. I think I've talked about it before, but it is a very difficult fight. So that's the question, right? And you need to take what the employer's saying and apply it to that question, right? If the employer's saying, oh, no, she resigned. Okay. You need to prove you didn't resign. If the employer is saying, no, this person tried to stab 7 coworkers and then spit on the face of the CEO. Well, that is very likely to qualify as a for-cause termination, so you'll need to prove none of that ever happened, right? And listen, employers, oddly, they'll lie sometimes. They will. Like this is, especially unemployment hearings are viewed as a little bit lower stakes, and you'll get employers who straight up lie way more often than employers I think are comfortable just straight up lying in, say, a federal court proceeding, right? So, you know, be ready. Be ready for something wild that you're going to have to disprove. So, you know, focus on what you have to prove. Start from that. None of this, my auntie says I'm amazing. No one, that's great. I'm glad. I'm glad that your grandmother thinks that you're swell. I'm happy for you, but no one cares. Not part of this proceeding, okay? Your teacher from 7th grade? No, not relevant. Unless they witnessed specific facts tied to the case, right? So identify what you really need to prove here, and then spend your time, I'm going to say 95% of your time, specifically addressing that. Get your evidence to prove that. Get witnesses to prove that. Present your case centered around proving that, right? That's what you have to do. That is best practice. Worst practice is everything else. Absolutely everything else. Anything else that you're spending time on. No. He doesn't pay paid holidays. You know what the ALJ is going to do with that? If you're lucky, refer it to the DOL and then never think about it again. It's not going to impact your case. Oh, this manager is a real jerk. He's a garbage human. Probably. You know what the ALJ is going to do with that? Not much. Really not much. It's not that relevant. Was the termination for cause? Did you resign? Right? These are the questions in New York State and in many other jurisdictions. Return to the questions. Those questions are what we're trying to answer with this very limited hearing, this very limited proceeding, right? So that is what I would stress to you. You should spend your time on. That is the best practice. And just leave the other stuff home. Don't even get into it, right? It's probably not what's going to carry the day here. I hope this was helpful. I hope this answered the question. And I hope that you get unemployment benefits. Very, very sincerely. I really do. If it was helpful, consider liking and subscribing. It helps me to help more people just like you. And I will check the comments on this video. I cannot stress enough, I do not handle unemployment hearings, right? In New York State, the state makes it very difficult for attorneys to get paid to handle unemployment hearings. We're not going to take your unemployment hearing. No matter what, we're not going to do it. Never. Call me up, scream at me, shame me, tell me I'm a bad. Yeah, I don't care. It's not going to happen. When you vote different and the state allows attorneys to get paid properly to represent people in unemployment hearings, then I'll represent people in unemployment hearings. Until then, it's just the state making sure it's difficult for you to get the representation you need. The attorneys can charge very, very little. They're supposed to get paid by the state if they win. The state makes us wait months, if not years, to get paid. And it's like no money for the amount of work involved. It's truly a joke. And you should be aware that the state has taken steps to make sure that you can't get representation to help you win these benefits. That should be meaningful to you. That should make you wonder why they did that. Okay? But the point of all this is I do not handle unemployment hearings. I do answer questions about unemployment hearings. If you need representation for an unemployment hearing, I would advise you to look into the Unemployment Action Center. They assign law students to represent people free of charge, is my understanding, in many, many, many jurisdictions and help people with their unemployment hearings. These are clinics often centered around law schools, so be aware of that. It can be very helpful. It is probably not the same or as good as a real attorney who has a lot of experience in this field, but it is probably way better than someone who says, boy, I just don't think I could ever represent myself at this unemployment hearing. And let me be clear that a lot of people feel that way, but 90% of you absolutely could do this. Because all you have to do is go in and be like, hey, here's what actually happened. I was not fired for cause. Or go in and just be like, hey, here's what actually happened. I did not resign, right? This is not, I always say rocket science, right? And then I think I said, but recently somebody said rock science to me, and I was like, what a moron. This person doesn't even know the phrase. And I was thinking about it. I was like, no, it works. Rock science is pretty hard too, right? Geologists work hard. It's difficult. Rock science is the same in rocket science, right? I might be babbling. Good luck to you. I'll check the comments to answer further questions down below.